In addition, in an order that came down last week, they have now ruled that in catastrophic injury cases, this is after the trial court and a unanimous court of appeals all ruled in favor of the insured. It was reversed, I believe, 4-3 in an order, a case called Burris. They said if a mother provides care to her child at home, a brain-injured child or a quadriplegic child, or to a spouse or whatever, and saves the insurance company millions of dollars in institutional costs because that family member, out of love, wants to provide the care, the family member need not be paid by the insurance company. Now, they said if you have a contract with your brain-injured child that they're going to pay you for your care as their parent or spouse, then the insurance company has to pay. Well, I invite the members of the majority of 4 to come to my office for the next deposition I have, in which the mother of a brain-injured child has said, show us the contract that you have with your child and tell us under oath that if your child doesn't pay, you will stop caring for them. Because those questions will be asked. Believe me, they will definitely be asked. Fully and 100% immunized all governmental employees. And that rule, in which they said the only cause, was a case called Robinson, in which, I think it was 2000, in which they reversed a decision going exactly the other way of the very same court, the Michigan Supreme Court, before Justice Markman came on. So they reversed themselves 1 year later on the exact same issue, and in fact they did it in a case where it wasn't even raised. They just said, oh, by the way, you know, we got it wrong a year ago, now that we have a new member and we want to fix it. They have reinstated privity of contract. Anyone who performs an act pursuant to a contract is now immunized from a lawsuit by someone in the general public who is injured. They have said if someone is working pursuant to contract, the only person who can sue them is the contractor. If you're walking down the street and they do something that harms you, too bad. That was in a case called Fultz. Premises liability is essentially gone. There is no duty to salt on an icy day. There is no duty to plow. There is no duty to fix potholes. There is no duty to clean up spills on floor. There is no duty even to a blind person or a child. There is no duty to warn. Dram shop litigation. It is now impossible to prevail in a case alleging that a bar served an intoxicated person unless you get the bar employees themselves to testify that the person was intoxicated when they served them. That's the new evidentiary requirement. So that's gone. Products. No duty to warn of any specific risks. If you say, just caution, this product may be dangerous in some situations, you've met the standard. And finally, automobile. In the Kreiner decision, they created a standard that is nowhere in the no-fault statute, and they raised the threshold for bringing a lawsuit for pain and suffering damages from a serious or significant injury to a catastrophic injury. And they did this with absolutely no textual basis, but you know, what difference does it make? And here are some of the cases that have been found since then not to be serious enough injuries to merit compensation from the at-fault driver. People who have had spinal fusions, had rods placed in their leg, knee injuries requiring multiple surgeries, unrepairable rib fractures, permanent limp, inability to walk for more than 10 minutes, need for lifelong pain management devices, herniated cervical discs, unrepairable rotator cuff injury, need for spinal injections on a regular basis for the rest of their life. All of these people have been denied their day in court, and this is just examples. And the court had to do 3 things to get to these radical decisions that they made. One was and again, if you read the works of Justice Taylor and Justice Young and Markman in particular, you will find that their attitude towards the notion of a court doing justice is equivalent to the Bush administration's view of the Geneva Conventions. It is a quaint and old-fashioned idea. The idea that judges should be engaged in justice, to them, is silly. It's childish. Their use of rationality. They have specifically said, we will uphold statutes that result in absurd outcomes. Of course, that's the way they read them, to come to an absurd outcome. So you can't challenge it on the basis of justice, and you can't challenge it on the basis of it being irrational. And they do this, of course, by, grabbing one of the 30 dictionaries that they have on the shelf to get the convenient definition. And Justice Weaver said, it is clear that when consulting a dictionary in performance of interpretive tasks, one is normally required to make a choice among several definitions. It is nothing less than a pretense to maintain that enforcing the statute as written, one is not making definitional choices. But indeed, the court doesn't always use the dictionary. Many of the cases that I have discussed, the plain language, if you'll use that expression, or using the dictionary, clearly would have required a decision in favor of the insured, and somehow in those cases the court always says, but we have to look at context. So textualism is a fig leaf covering what I believe is judicial malevolence and a complete disregard for stare decisis. And I will tell you two quick quotes from former Supreme Court justices. Justice Levin said, a few years after he left the court, that there is only one rule of law left in Michigan, and that is, which side of the V are you on? Are you the plaintiff or are you the defendant? Because we know who wins before the case is argued. And Justice Brickley, I was speaking with one of his last clerks, and his clerk described to me how Justice Brickley, sadly, sometimes would take an old book off, an old reporter off the shelf and say, well, let's open it up and see what we can reverse today. So following me is one of the two Michaels, either Michael Pitt or Michael Lee, I'm not sure who.